Jane, do you know what is winding up?
It's mean the company is closed. Teacher.
That correct, but let's me explain the full meaning.
All right, teacher.
Definition of winding up, Section 431. The provision of winding up in this Act shall apply to the winding up of a company for either mode specified in subsection 432 subsection 1, unless the context otherwise requires. Definition of winding up. Winding up is the process by which a company is brought to an end and the asset and the property of the company are redistributed to pay for its debts, and the balance is distributed among the members. Winding up also sometimes referred as liquidation or dissolution.
Hello, Miss. Can you explain about most of winding up in Section 432, subsection 1A? Section 432, subsection 1A of the Companies Act 2016 empowers the Registrar of Company (SSM) to strike a company's name off the register if the company is not carrying on business or is not in operation. In simple terms, this means that when a company has stopped doing business or is no longer active, the registrar has the legal authority to remove it from the official register of companies. The purpose of this provision is to ensure that only active and compliant companies remain on record, thereby keeping the register accurate and up to date. Oh, I understand right now. So, can you explain about most of winding up in Section 432, subsection 1B next? Of course can. Section 432, subsection 1B of the Companies Act 2016 provides that the Registrar of Companies (SSM) may strike a company's name on register if the company is being wound up and the registrar has reasonable cause to believe that no liquidator is acting. In simple terms, this means that when a company is in the process of winding up, closing down, but there is no liquidator actively managing the process, the registrar has the power to remove the company's name from the register. This provision ensures that companies which are left unattended during winding up proceeding do not remain indefinitely on the official register.
Section 432 bracket 2 bracket A of the Company Act 2060. How about modes of winding up in Section 432 bracket 2 bracket A? In Section 432 in bracket 2 bracket A Companies Act 2060, it means that if a company is still solvent, meaning it can pay all its debt, the member can choose to close it down voluntarily. They do this by passing a resolution during a members' meeting. In that same meeting, they will also appoint a liquidator who is responsible for managing for the company closure, such as selling asset, paying debt, and distributing any remaining money to the members. What does Section 432 bracket 2 bracket B means about creditor voluntary winding up? In Section 432 bracket 2 bracket B Companies Act 2060, it means that when a company becomes insolvent and cannot pay its debt, the company can decide to close down voluntarily. However, since it owns money, the creditors will be the one who have control. They hold a meeting to discuss the situation and appoint a liquidator to take charge of selling the company's asset, paying of debts, and handling the remaining affairs fairly among all creditors.
Section 464, Subsection 1 of the Company Act 2016. Can you tell me what this section is about? Of course, this section is about a petition for winding up. What does that mean? It means an official application made to the court to wind up or close a company legally. So, who can apply to the court to wind up a company? This section explains 9 parties who are allowed to apply to the court. Let's go through them one by one. Section 464, Subsection 1A of the Company Act 2016, application by the company itself. We can't continue our business anymore. The debts are increasing and there's no profit. I think it's time to close the company. I agree. We have losing money for 2 years. Maybe we should apply to wind up the company through the court. Yes, I will ask our lawyer to file a winding up petition under Section 464, Subsection 1A, since the company itself want to be wound up. Court decision. The application is accepted. The court will issue an order to officially wind up the company. Section 464, Subsection 1B of the Company Act 2016, application by a creditor. XYZ Berhad still hasn't paid the 80,000 ringgit they owe me, even after I sent them several reminder letters over the past 3 months. In this case, you can file a winding up petition against the company. You mean I can ask the court to wind up the company because they didn't pay their debt? Exactly. Under Section 464, Subsection 1B, a creditor like you has the right to file a winding up petition in court. Alright, I will do it. Hopefully, I can recover some of the money from the company's asset later. Section 464, Subsection 1C of the Company Act 2060, application by a contributory. I'm not satisfied. This company hasn't been active for a long time, yet the director keeps using company money without proper financial reports. I'm just managing the company's expenses. There's no need to bring this to the court. As a shareholder, we have the right to apply for winding up under Section 464, Subsection 1C. I want the company's asset to be distributed fairly among all members. The court decision. Your application is valid. The court will investigate and decide whether the company should be wound up.
Who can ask the court to wind up a company? Well, under Section 464, Subsection 1D, the liquidator can file a petition to the court, even if the company is already being wound up voluntarily. Yes, the liquidator can still step in and ask for a court order. Can the minister be involved in winding up a company? Yes, Section 464, Subsection 1E allows the minister to file a petition, but only on specific grounds. What grounds? Those listed in Section 465, Subsection 1D or L. What if a financial institution needs to be wound up? If it is a licensed company under the Financial Services Act but not covered by PIDM, then Bank Negara Malaysia can file a petition under Section 464, Subsection 1F. So the central bank steps in for such companies? Exactly, especially for financial stability.
Section 464, Subsection 1G of the Company Act 2016. Maya, if a company is licensed under the Financial Service Act or the Islamic Financial Service Act but isn't members of PIDM, who regulates it? It's simple, Alex. It is not a member of PIDM. The one supervising it is Bank Negara Malaysia. Section 464, Subsection 1H of the Company Act 2016. Lina, I come across the place the registrar on the ground specified in paragraph 465 subsection 1k. What does that mean exactly? Good question, Vinesh. It means the registrar of companies has the power to act. For example, to apply for a company to be wound up, if there's a valid reason under that paragraph. A valid reason? Like what? Well, under paragraph 465 subsection 1k is when the registrar believes it's just and equitable, fair and reasonable for the company to be wound up. For instance, if the company has stopped operating or is no longer fulfilling its purpose. Oh, so it's about keeping this fair and lawful. Exactly, the registrar steps in only when it's the right and fair thing to do. Section 464 subsection 1I of the Company Act 2016. Sarah, I saw this line in the case of a member institution under the Malaysia Deposit Insurance Corporation Act 2011. Who actually supervises those institutions? Good question, Amir. If a company is a member institution under that act, it means it's part of PIDM, the Malaysia Deposit Insurance Corporation. PIDM? What does it do? PIDM protects depositors' money if a member bank fails. Under Section 99 of the Act, PIDM has the authority to handle and manage such situations. Got it. If it's a PIDM member, PIDM in charge. Exactly, Amir.